Hi everybody, welcome to Hot Topics for Clerks. Today we have three speakers from Association of Towns. Sarah, Katie, and Lori will be speaking today. This session is going to run from 10:45 till noon. If anybody has questions, you could ask them after. There's going to be three different speakers, so if you could raise your hand and ask a question after each of those, feel free to do so. Please silence your cell phones and step out of the room if you must take the call. Exit is located at the back of the room here. Thank you, and I will hand it over to the first speaker.
All right. Good morning, everybody. Can you hear me? Okay. Yes, all right. I'm going to try to speak over the excitement over there. So, Felicia, thank you for having us here. We're so happy to be here at Tug Hill. My name's Katie Hodgdon. I'm one of the attorneys with the Association of Towns, and with me are my coworkers and friends, Sarah, Brancatella, and Lori-Mithen. So we're going to talk to you about some hot topics that are going on for town clerks. You have the handout that you can follow along with, but specifically video conferencing. There's some hot new updates with that. The old authority and the new authority. Social media and posting on your account as a public officer. There's just some Supreme Court cases on that Sarah's going to talk about. Compatibility of office, credit cards, both the use of for town charges and also the new credit card surcharge law that many of you likely got an email about in January about having to comply with that. Your ability to waive penalties as a collecting officer, and especially as it relates to checks that have been washed or stolen, which is happening more and more frequently in the recent collecting cycles. Civil service and deputies, and if we get to it, early mail ballots in special town elections, because that's new and pertinent. So we have an hour and 15 minutes. I'm going to try not to talk like an electioneer so we could get through all of it. But if you have any questions at the end of video conferencing, you can ask. And really, whenever, we'll let it happen organically too, right? But we do want to get through all of the material. Sound good? All right. So video conferencing or calling into your meetings, FaceTiming into your meetings as a public body. So there's two different types of authority. You have the original authority that always existed in the law, well, ever since video conferencing has existed. So I'm going to call this a pre-COVID authority. You have Public Officers Law, Section 102. Which defines, in its definition of a meeting, it includes the use of video conferencing. So this was your ability to video conference in, or I think back in the day it was you would Skype in to the town board meeting and to your village board meeting. This authority has always existed. It didn't go away with COVID. It did not go away with the new extraordinary circumstances authority that you also have. So in order to use this authority, which you had pre-2020 and which you still have today, basically a member of the public body can video conference in so long as their location is noticed at least 72 hours in advance to the extent practicable, and that the members of the public have the ability to attend via at that location. So the location is open and obvious. So for example, you're here at the Tug Hill conference, right? Right. So let's say you had a town board meeting last night and you wanted to attend, but you were also here. You could have attended from here. So let's say you went downstairs into the lobby, you notified the news media. You don't have to publish it in the newspaper, but you notify the news media that you are video conferencing in from Verona at this location at this time, and the members of the public are welcome to attend. If the members of the public could see you participating, you've noticed, and it's open, you can video conference in at that point from here, and your votes count towards the quorum, your votes are counted. So this authority always existed, and it still exists, right? So, but then after COVID-19, lots of governing bodies, public bodies, started using video conference more frequently, right? I guess that's an understatement. And so to address this, the governor signed a bill 2 years ago, or 2023, that provided for extraordinary circumstances in video conferencing. So the main difference to think about here is that if the town or village board adopts a local law, you have to adopt a local law, opting into extraordinary circumstances. If this happens, then the individual that's video conferencing in does not have to disclose their location. So let's say you're using an extraordinary circumstance. We'll use your attendance here because you can define, the governing body can define extraordinary circumstances to include, you see at the bottom it says disability, illness, caregiving, responsibilities, etc. That's not an exclusive list. So if your governing body includes attendance at conferences for training, then that would be considered an extraordinary circumstance. And you could have participated from here under extraordinary circumstances without noticing your location to the public. So you're not opening up your hotel room to the members of the public to come and attend because you're doing it via extraordinary circumstances. So in order to use this, the governing board does have to adopt a local law opting in. And within that, the board can say that all of our public bodies, so the zoning board, the planning board, can use extraordinary circumstances, or we're authorizing it for the town board, and then those bodies themselves can determine whether they want to use extraordinary circumstances as a planning board, as a zoning board. It's all up to the town board or the village board to make that determination in the local law. In order to use this, though, you do still have to have a physical quorum. So if you have a 5-member board, you have to have at least 3 members present in order for your other board members to use extraordinary circumstances. So if you have 3 members present, then 2 of them could use extraordinary circumstances. And the thing to think about here is that if you're calling in via, or if you're video conferencing in, then you also have to offer that online platform to anybody that wants to attend the meeting, so members of the public, right? So if you allow public comment during your meeting in person, and then you have someone video conferencing in, you also have to allow public comment via that video conferencing platform as well. You have to have a written policy that governs extraordinary circumstances and the policies or the procedures to follow, which has to be on your town or village's website. So if you want to use extraordinary circumstances, you have to also have a website. And the recording of the meeting, because we get questions, if do we have to have all of our meetings recorded and posted on our website? The short answer is no, unless you are video conferencing in. Then you are required to have the recording available and posted on your website within 5 business days. So this was set to sunset in July of 2024, so a couple months, but as a part of the 2024-2025 enacted state budget that was just adopted a couple weeks ago, it was extended through July of 2026. So you could still use the extraordinary circumstances through 2026, or still opt into it, I should say, and you still have that old authority as well. Any questions on video conferencing? Yes?
I have one. You say the public gets to have a public comment, do they have to register that they're going to be attending from video, or does the public get to sign on and be there?
So the question is, you have to allow the public to comment. Do they have to sign in to be able to comment, or can they just come in and Zoom bomb you, essentially, right? So, which that's never happened, of course, right? So if you open up the floor in person, that's when you have to open it up in online. And if you have a policy that governs, just like you have a policy governing public comment at your physical in-person meetings, you can have a policy governing comment during video conferencing that if you wish to participate, there are some parameters to follow, such as registering at X, so that people just, at X time, so that people just can't come in and then be like, well, we want to ask all of the, or make all these crazy comments and interrupt the board meeting, essentially. So a good question. Anybody else? Yes?
Did you say that from a remote location, a board member would have the ability to vote?
So the question is, from a remote location, would the board member have the ability to vote? Yes, if it's under extraordinary circumstances that the town's opted in, and you're using it under the extraordinary circumstances, you meet the parameters that the town board set forth. So if it's for illness, let's say they've opted in, you have an illness, you let the board know, you can participate and be counted towards the quorum that way. If it's under the old way, where you're just video conferencing in and your location is noticed, then yes, you can too. Although keeping in mind that there's a caveat in town law that all meetings of the town board have to occur within the town's physical borders. There is still a meeting occurring, so I tend to disagree with some others that say you have to call in from within the town's borders, or when I say call, video conference. But The short answer is yes, your vote will count as long as it's open and noticed under the old authority, and that you properly use the extraordinary circumstances under the new authority. But yes, your vote does count as long as you've complied with all that.
So without fitting into the extraordinary circumstances, the answer is no.
Well, if you're not using the extraordinary circumstances, your vote will count if you have notified the news media of your location, the public can attend from your location, and the public can see you participating. But if you're calling it, you're video conferencing in from outside of the town's borders, just know there's an opinion that says you should be within the town's borders. But if you want to avoid that entirely, the town could adopt a local law expanding the ability of those to participate via video conferencing to be statewide or something like that. If there's ever anything controversial that you're voting on, you might want to consider that, because you don't want to say there's a procedural defect in voting. Does that make sense? It's just a lot of words. But okay, so if we don't have any further questions on that, Sarah is going to talk to us about social media.
And I'm going to set a timer because I tend to be a little bit lengthy. Okay, how many of you have a personal social media page? How many of you have a page that you consider your public officials page? Anybody have a campaign social media page that they then decided to open up to the public? Okay, there's a bunch of different types of social media pages that you can have as individuals. And recently, the Supreme Court in March 2024 issued an opinion about a public officer acting what he thought was as in his personal capacity and deleting comments from his Facebook page. As we all know, it's called Lindke v. Freed. As we all know, the First Amendment exists, right? So what happened in this case was the defendant, James Freed, he was in college in 2008, and he created a personal Facebook page. One that, he's in college, it's just personal, right? Apparently, and I didn't know that this existed, there's a 5,000 person limit for how many friends you can have on Facebook. That is my nightmare. Okay, I don't want 5,000 friends, but this guy apparently hit 5,000 people, 5,000 friends. So he converted his page to a public figure page. And this meant that anybody could follow him, anybody could see his page. You didn't need to be friends necessarily with him. After he graduated from college, he joined the glitz and glamour of local government and was appointed to city manager in Port Huron, Michigan in 2014. He continued to use his Facebook page that he had since college. That was, again, a public official page or a public figure page. He did things when he got appointed, like change his profile picture to him in a suit with like the city insignia on his lapel. He changed the About Me section to say, I'm the new city manager in Port Huron, and he included a general, just like public email for the city, like info@cityofporthuron.com, something like that, right? He posted a mix of personal and professional stuff. So he would post a lot of things about his daughter, about home reconstruction projects, about his dog named Winston. I love that the U.S. Supreme Court was like, yeah, we got to include the dog's name in this opinion here, okay? The daughter's not included. I don't know what her name is, but the dog's name is Winston. So there were a lot of posts about Winston, daughter, but then he would also mix things in there like job-related things, public announcements. He one time posted a survey asking people to participate in a survey on affordable housing within the city. He would post have posts of when he would go visit local schools, stuff about hiring opportunities. So he did a mix of personal and professional. Every once in a while, he would engage in the comments, and he didn't have a formal policy, but every once in a while, he would delete comments that he felt were stupid or just not worth it, right? So he just decided to not delete things at will. This went along fine, okay, totally okay, until COVID-19 happened. And then you have the plaintiff, Kevin Lindke, and he was really not happy with how the city reacted to COVID-19. So he decided to take out his frustrations on James Freed's Facebook page and would post comment after comment after comment after comment, being really critical of the city's response. James Freed was like, I don't want to deal with this, delete. So he started off by just deleting comments, and eventually it escalated to the point where he blocked Kevin Freed from accessing his page altogether. So he couldn't comment on anything and could only see, I believe, in like a limited capacity. He couldn't engage. As a result, Kevin Lindke brought what's called a 1983 claim, and it alleged that James's Facebook page was a public forum, and deleting comments and blocking him was viewpoint discrimination, thereby violating his First Amendment rights. This gets a little bit in the weeds here, and I hate to get like too legalese, but it is a really important case, and it is really relevant to how the case turned out. A 1983 claim is basically saying that a government actor or the government denied me my federal rights, denied me my constitutional rights. It refers to a state action, but the Supreme Court has said many times over many different cases that local government counts as a state action. So when I say a state action, don't be like, haha, it doesn't apply to us, it's just New York State. No, local government can also stand in for the state here. So the question was really, was James Freed acting as a government agent? Was he acting in his capacity as a government official? Was it a state action? That is what the court had to determine. And there are a bunch of different opinions from different circuits. We're in the Second Circuit here in New York, but there are a bunch of different opinions between the Second Circuit, the Sixth Circuit, the Ninth Circuit, and that's why the Supreme Court came up with this, decided to take this case, because they were like, all right, we'll decide this once and for all. The first thing that the court noted, and I think that this is so important, is that, and I say this all the time, just because you are a public official, you're also a normal person too, okay? Like, you're also a person, and public officials also, as private citizens, have their own constitutional rights. Just because you became a public officer doesn't mean that you can no longer do anything, or anything that you do might be violating somebody's federal rights. What the court did here is they created a new test to determine when social media activity is attributable to a state action or to a government action. It's a two-pronged test, and it says, number one, does the official have actual authority to speak on the government's behalf? And number two, does the official purport to exercise that authority when speaking on social media? Looking at the first prong of the test, does the official have actual authority to speak on the government's behalf? The court said that actual authority is way more important than appearances, right? The first prong of the test focuses on what authority does the person actually have, not just what do they appear to have. And what authority an official actually has comes from things like statute, regulation, law, custom, and usage. So it doesn't always have to be like statutorily authorized that you have the authority to do this. It could be custom, it could just be like a practice that has been engaged in for so long. And the court was clear to say that custom and usage must encompass persistent practices so permanent and well settled that they carry the force of the law. So, you might have a position within your municipality, and since the town was founded, that position has always done this thing, okay? That would be persistent custom and usage, a persistent practice. Otherwise, as I said, a statute, regulation, law. The court also said that you can look at job descriptions to determine if you have actual authority, to determine if an official has actual authority. But they also made clear to say you can't rely on overly broad job descriptions, right? You might have a job description that says interacts with public as part of, like, I don't know, a town board member. Technically, yeah, that is that is something that you do, but that would be considered overly broad. So you have to look at something more than job descriptions. And as I said, appearing to have authority is way different than actually having it. That's the critical question on the first prong of this test. Also, the authority to speak has to be connected to the alleged infringement. So what do I mean by that? I mean, let's say that James Freed posted about his dog Winston, okay? It is fairly clearly not a government action there, right? You know, it's his dog Winston. And let's say that he deleted a comment from that specific post. Depending on how the claim was brought and depending on certain actions, right? So the speech, the post has to be in your government capacity, and the deleting of the comment has to be on something that's said in your government capacity. That's what I mean by you have to connect the speech to the alleged infringement. The second question to ask is, does the official purport to exercise government authority when speaking on social media? You know, are they invoking that? Are they alleging that they are speaking on behalf of the government? And the court made sure to note that, like, context matters, right? When somebody is purporting to speak about something. Just because you are a public official, again, you are also a normal person, and you can talk about work among friends, among family members. You can do that. If you are at a barbecue and you are not a municipally sanctioned barbecue, I mean like a friend's birthday party barbecue, okay, just to be clear, right? If you're at like a friend's birthday barbecue and you're talking about stuff that's going on in your municipality, that is a heck of a lot different than if you're up on a podium in front of town hall. Right? Context matters for determining whether an official is purporting to have the authority to act under the state, on the government's behalf. Mixed-use media it really blurs lines. The context between the barbecue and standing up on a podium is really easy to distinguish, right? But in a digital space, it's a lot weirder. And the court said, yeah, mixed use social media, probably not the best idea, all right? It makes things blurry. However, there are some things that public officials can do to make clear that they are not purporting to speak on behalf of the government. And the biggest thing is including a disclaimer that says, all viewpoints are my own. That is, if you are going to have a page that you believe is personal, but you still want to make it available to the public and maybe post about some of your municipal responsibilities, I highly recommend, strongly recommend including a disclaimer saying that you are not speaking on behalf of your municipality. All viewpoints are your own. You're speaking on behalf of yourself, one individual. This is not an irrebuttable presumption, all right? This is not the silver bullet that's going to save you every time. The court made sure to say that, and I think that we'll see some case law develop over time, right? But this is the new test, so we haven't had a chance to test it out. But yeah, the court said it's not an irrebuttable presumption, but it creates a strong presumption that you are speaking on behalf of yourself and not in your government capacity. Other things to look at would be, is it a social media account that is handed down from office to office, like a Twitter handle maybe has at state comptroller NY, and it just gets handed down from whoever has the huge shoe, like whoever has to fill Tom DiNapoli's huge shoes. I love Tom DiNapoli. He's my favorite elected state official. But yeah, so if you have a handle like that is used by the office, then that is far more likely that you are speaking on behalf of the government instead of your personal capacity. Just a few other notes. As I said before, connecting the infringement to the speech. Deleting comments from a specific post is only going to have the state action analysis apply to that post, not your entire page. That's my timer. When you block somebody from, I only have like one more slide left. When you block somebody entirely from engaging in your page, that brings into question your entire page. So deleting comments is a little bit of a safer action than blocking somebody entirely. Also, I want to be really clear here. I am not talking about your municipal website. If your town or village or whatever, if you have a Facebook page, if you have a social media site, this is not what I'm talking about, okay? Do not delete comments from those pages. Those are clearly government action. Okay, so I'm talking about, when you have a page that you're like, this is personal. Yeah, so blocking somebody from an entire page brings your entire page into question. So yeah, practical advice, include a disclaimer, be wary of blocking because it will bring all of your posts into question. And just know that doing something like posting pictures of your cat or anything else personally important to you, I'm not sure what else would be more important, but posting pictures of your cat does not automatically make your social media page a personal one. So don't think that that's going to inoculate you from that. Anyway, any questions? Yes?
I have a personal Facebook page. Once in a great while, like, I post announcements. I don't block anything, and I don't post opinions on behalf of the town. But once in a while, like for instance, the other day, our cost for transfer site tickets is increasing. So I put that on there as an announcement.
Mm-hmm.
Or I say, well, fishing licenses and hunting licenses are coming out soon or whatever, Is that considered personal, or is that considered as me as a citizen, or is that on behalf of the town?
So my recommendation would be to have have a disclaimer on your page that says this is personal. Mm-hmm. And that's not that different than just because you're a town official, you can still talk about town, or just because you're a public official, you can still talk about government stuff with your friends, right? Mm-hmm. You can think of that as maybe equivalent to announcing it in your personal capacity.
I never put an opinion on there.
Yeah, I would still put just all posts are, my personal posts,
Okay.
spoken in my own capacity.
Mm-hmm.
I would definitely include some sort of disclaimer like that. Yeah.
So just yesterday on my personal Facebook page, I shared a bunch of town, I linked the events that the town is sponsoring, and I shared their page.
Yep.
Is there any protection there sharing the town's page on my personal versus me just putting it as my own thing?
No, not really. I would still put the disclaimer, right, if it's your personal page, because again, you are allowed to talk about town things in your, in your personal capacity. You are definitely allowed to do that. If you think that this is a personal Facebook page of yours that you don't want to be, you want to have the discretion to delete comments, then I would put the disclaimer on there. Absolutely. Yes.
So if you say don't allow comments at all on any posts,
Yeah.
is that an issue?
That's great. I love that. And if you have a municipal social media page, definitely do that, okay? Definitely do not allow comments on a municipal social media page. Don't delete them, just don't allow them in the first instance. Okay, I'm going to turn this over to Lori. She's going to talk about compatibility of office.
I like her name.
All right, so I apologize to anybody who might be with a village. It's all town-centric. But the basic rules are the same. The statutory references just probably aren't going to be too helpful for you. But I'm going to talk about compatibility of office. There's lots of different things to look at when we're talking about compatibility of offices. So what is compatibility of office? When does it come into play? It comes into play when one individual is holding more than one position. Sometimes it's a small community and you've got an individual who's wearing several different hats, and there's some guide rails that the courts and the legislature has given us to help us understand what we can and can't do. So the general rule that we start with is a person may hold multiple offices unless, and then there's some places to look. There's a statutory prohibition, so the state legislature has told us we can't hold these two positions. You have a local law or a provision in your ethics code that has determined that these two positions cannot be held by the same person. And then finally, the courts and primarily the Attorney General's office have created a body of common law examples of when we can hold two positions. And that's a two-part analysis if you get down to that, the common law prohibition. Is there a conflict in duties, and is one position subordinate to the other? So let's start with statutory prohibitions. So in the town law, we have a couple of examples of where the state legislature has said that two positions in the state legislature's opinion are incompatible. One position cannot be held by, or these two positions cannot be held by the same person. Sometimes you're going to see that it's a generic prohibition, and sometimes it might be very specific. So a generic prohibition can be found in Town Law Section 20. It says you can't hold two elected town offices at the same time. A more targeted or specific prohibition can be found in Article 16, which is your planning and zoning provisions. Specifically, you cannot be both a town board member and serve simultaneously on your zoning board of appeals or on your planning board. So I always think it's a great idea to start with, is there a statutory prohibition? Because a lot of times, if there is, it might be a hard stop, although we will see at the end of my remarks that there could be a twist. But oftentimes a statutory prohibition is a hard stop. And it's a good idea when you get a question to not trust your memory and to go back and check each and every time. Because, for example, state law was amended in the early 2020s to prohibit a municipal official associated with a municipality that sponsors an IDA from also being a paid employee of the IDA. Prior to, I think it was like 2021, there was an Attorney General's opinion that came out in the 1970s that was like, oh yeah, it's okay as long as you don't have any of the other issues that we're going to talk about in a minute. There's no statutory prohibition here. If you had just stopped at the Attorney General's opinion and not gone back and looked at the statute, you wouldn't know that in the early 2020s, the state legislature amended the law. So I suggest when you're trying to figure out if there's a statutory prohibition, every time the question arises, ask somebody or go check the statutes. So the next place we want to look, has your municipality adopted a local law? Under the Municipal Home Rule Law, town boards, village boards, they have the authority to determine qualifications of offices by local law, and the Attorney General's office has said in an advisory opinion that you can include prohibitions of holding two positions. Another place that you could look would be your municipal ethics code. Your municipal ethics code, according to the Attorney General's office, can include prohibitions on simultaneously holding offices. Some common examples there might be you can't be a municipal official and also hold certain political party positions. There's a couple of Attorney General's opinions that look at that in more detail based on some case law. I always think it's a good idea to work with your municipal attorney if that's something that you want to include in a municipal code of ethics. But that might be an example of where you could see that in a municipal code of ethics. Also, you probably would need to do this or look in your local law, but it might be incorporated also into your code of ethics, particularly if your municipality has adopted the code of ethics by local law. You may see a prohibition. For example, the city of Albany has said in their code of ethics, you can't be both a city official, you cannot hold more than one city office. So that's a pretty broad prohibition that they've imposed upon themselves. So you always, again, want to check, is there a provision in your code of ethics, or is there a local law that might be on point? Maybe your local law has been incorporated in the town's employee handbook or personnel policy. So now we get to the common law prohibition. The common law prohibition came to us in a decision issued by the Court of Appeals in the late 1800s. They use fun language like repugnant. But essentially what this looks at, if you don't have a statutory prohibition, you don't have a local prohibition, there may be a common law prohibition. And it's a two-part analysis that you want to look at. Essentially, is one position subordinate to the other, or are the duties of the two positions inherently in conflict? And the Attorney General's office has extended this standard to both holding a position of employment and a public office, or two positions of employment. So let's first look at subordination. This one is fairly self-explanatory. You cannot be both the chief cook and bottle washer. You can't supervise yourself. In the parlance of town clerks, you could not be both the town clerk and the deputy town clerk. In the parlance of the town board, the Attorney General's office has said you can't be both a town board member and also a town employee. And they've extended that out fairly broadly. It's not just employees over whom the town board may have direct hiring authority. They have said, for example, that a town board member cannot also be a highway department employee, even though the highway superintendent has statutory authority to hire employees that work on the crew within the highway department. They have said that essentially the town board employs everybody. They set general employment policies, they approve collective bargaining agreements, they set salaries, compensation, et cetera, and so they would consider that to be supervising yourself. Conflicts of duties is a little bit harder to parse out. It's not as easy to figure out that you can't supervise yourself. In this capacity, you have to actually look at the individual duties of the positions in question, and you have to see, are there any frequent, inevitable, and inherent conflicts between the duties? It's got to be more than a mere possibility in order for it to meet the common law incompatibility test. A common example is, would these two positions, if held by the same person, erode a system of checks and balances? And we'll talk about that in the town clerk's context in a few minutes. But a common example for the towns would be, you can't be both a code enforcement officer and a member of the Zoning Board of Appeals, because under town law, the Zoning Board of Appeals has the authority to review code enforcement officer decisions that are brought to them on appeal. They can modify them, they can overturn them, they can sustain them, and if you are the code enforcement officer on the ZBA, you're essentially reviewing your own work. And so those would be inherently, frequently, and inevitably in conflict, and it's an erosion of the statutory checks and balances that we see in Article 16 of the town law. Did it advance? It did, okay. All right, so in the context of the town clerk's office, let's just take a look at some examples of where the Attorney General's office has said that two positions are incompatible under common law. The Attorney General's office has said that the town clerk cannot also be the deputy supervisor, the town bookkeeper, or the town confidential secretary. And this is primarily in towns that do not have a town comptroller, although with the deputy supervisor, it would likely extend beyond towns with a town comptroller. The reason is because our fiscal chapter, Article 8, divides the responsibility for the payment of claims between the town clerk's office, the town board, and the supervisor's office. The town clerk's office is a separate set of eyes that the legislature has said, we want you to take a look at the claims, you collect all of the claims, you put them on what the statute refers to as an abstract, and then you give those claims to the town board. They audit them, the claims that are approved by the town board for payment, then you put on another document, whatever you want to call that, a warrant in tax collection parlance as an example, which then goes to the supervisor's office, who then has the authority to pay the claim. So there's checks and balances built into the Article 8 fiscal system that the state legislature has put in place, and the Attorney General's office has said that that system would be eroded if you have individuals from the town clerk's office also serving in the supervisor's office. And the deputy supervisor is operating on behalf of the supervisor if the supervisor is incapacitated or unavailable or has a prohibited conflict of interest. So the conflicts of the supervisor would be extended to the deputy supervisor. They've also said it even extends to the confidential secretary, even though your confidential secretary may have probably not very much, if anything at all, to do with the fiscal checks and balances set forth in Article 8. They don't think it's a good idea in this context because you could be in a situation where you are putting the town clerk in a position subordinate to the town supervisor as the supervisor's employee, and that would then eliminate the checks and balances and the objectivity that the statute hopes would be available for the town clerk's office.
I have a question.
Oh, sure, absolutely.
Can the town clerk, though, then be like the secretary for the planning board?
Yes, and we'll talk about that in just a minute, but that's a great question.
Says in one of the future.
Oh, I
I had the same question there for a minute.
Absolutely, we're right up there. Absolutely, so here's examples of where the Attorney General's office has reviewed the duties and responsibilities of the town clerk's office, and this is all also extends to the deputy town clerk against other town provisions or positions. So tax collection. In many towns, the town clerk is the tax collector. either because the position of tax collector has been abolished and the duties transferred to the town clerk's office, or because the town board has converted the tax collecting position from elected to appointed and appointed the town clerk or the deputy town clerk to serve as the tax collector. But because the town clerk can already perform that function under town law, those positions are considered to be compatible. There is a caveat there. Remember when we went back a few slides ago with statutory prohibitions, the town clerk cannot be appointed to fill a vacancy in the elected office of tax collector, because even though they're appointed to that position, the position itself is still elected, and we can't hold two elected town offices. So if you're in a town that's retained the separate position of town tax collector and that position is an elected office, even if it's vacant, the town board cannot appoint the town clerk or well, I guess they could appoint the deputy town clerk, but they can't appoint the town clerk if that position is elected within the town. It's a weird quirk, but oh, yes.
Can the town clerk be appointed to the deputy receiver of taxes position?
I would say yes. Those positions would be compatible. The question was, can the town clerk, the elected town clerk, be appointed to the office of the deputy receiver of taxes? I don't see any reason why not. Do you, Katie?
No, just let's say it's an elected position, the elected receiver, and they're appointed as a because this comes up often when the receiver's collecting and they need assistance, so they would often deputize the town clerk, and it's a deputy position, so it's not an issue because it's appointed, but when that receiver's absent, they're then acting in their stead. But
so your thoughts are?
That, yes.
Okay.
It wasn't a trick question. It was just an example that's come up.
I like it when we're on the same page. Makes everything easier. The Attorney General's office has also said that the town clerk or deputy town clerk may be appointed to be the planning board secretary, the ZBA secretary, and then there's a body of opinions that have been issued regarding the court clerk. So as long as the town justice is okay with the town clerk or deputy town clerk serving as their court clerk, they can be appointed to serve in that capacity. Any town clerks here also serving in another office? What office are you serving in?
I'm the town clerk, but I'm also co-chair of the planning board.
You're on the planning board. Nice. Okay. Yes.
I'm town clerk and planning board secretary.
Okay.
And overseer of cemeteries.
You wear many hats.
I wear 6 hats.
Oh boy. Okay. You guys are busy. Alrighty. Okay, so just to recap, when we're trying to determine if two offices are compatible, we look first, is there a state statute that says these two positions cannot be held by the same person? Is there a local law or a provision in our ethics code that says these two positions cannot be held by the same person? Is one position supervisory to the other? Or is there an inevitable and inherent conflict in duties between the two positions? What are some of the impacts of incompatibility? The courts have given us a little bit of guidance on this. Typically speaking, it would be driven by a court decision. Somebody who believes that an individual shouldn't be serving in two positions may make the argument that one of the positions is vacant and brings what's called a Article 78 writ of mandamus to get a court to direct the town board to fill what they believe is a vacancy. That was the case in Smith v. Dillon. And the court said in that case that you automatically vacate the prior held position. Or a court may order that the individual has to make a choice. Which of the two positions do you want to have if the court agrees that the position is incompatible? It could be brought by somebody who's interested in serving in one of the positions. But usually speaking, it would get to court. The town itself probably is not going to bring the decision. They typically don't have the authority to ask whether or not a position is vacant. They may bring what's called a declaratory judgment action to have a court look at whether or not two positions are incompatible and thus one is vacant. But probably it's not going to be the case that it's brought by the town board because they most likely made one of the appointments. So they probably already believe that the positions are compatible. But that can be one of the impacts of incompatibility. And how do we know if somebody has accepted a second or a subsequent position? They need to take and file their oath of office with the town clerk, and they have to qualify for that office. So they have to be a town elector. So let's say you're in a town and you are the elected town clerk and you didn't run for the office of supervisor, but everybody loves you and they wrote you in and you got you got the majority of the votes. So come January 1st, you have to make a decision because you can't serve in two elected town offices. Do you want to continue to be the elected town clerk, or do you want to switch and become the elected supervisor? Just because you're elected to an office doesn't necessarily mean you've accepted the second position, right? So you would accept it if that's the choice that you make by taking and filing your oath of office for the second position and qualifying for that office. Okay. Yes. If it's an infrequent conflict between the duties of the two positions, it's minor, it's occasional, it hardly ever comes up, it's not inherent conflict between the two positions, you can probably cure it with recusal. It doesn't mean that you have to vacate one of the positions or you can't hold two of the positions. You just have to recuse yourself when a conflict arises. This is most often probably going to happen if you're a board member and also the town clerk. Board member being a planning board member or ZBA member, something like that. If there's an occasional conflict that arises, you can probably cure that with recusal. And then finally, the Attorney General's office has given us what I like to refer to as a get out of jail free card. Doesn't apply across the board, but it does sometimes apply. So they have recognized a local law exception to compatibility of office issues. It has to be in the overall public interest. There has to be a lack of willing or available residents to fill the position. And that position probably should have some kind of special expertise or license or certification. If that's the case, and you have the authority to do so, you can adopt a local law. It's really a good tool for rural communities that don't have a lot of choices in terms of who might be able to serve in particular positions, particularly if residency is one of the requirements of the position. You could take a look at that. You cannot supersede a general state statute, so it's not going to be applicable in the IDA situation, as an example. But it might be helpful if there's a prohibition set forth in the town law in a provision that we can supersede. And as Sarah talks about this from time to time, and I'm going to borrow your comments because I think they're helpful. It's a good idea to be able to demonstrate that you have actually made an attempt to fill the position before you look at adopting a local law to allow one individual to hold positions that would otherwise be in conflict. So that if somebody challenges it, you can say, we made a good faith effort, we advertised for it, here's how we advertised for it, we waited, nobody applied that was qualified, that had the certifications. This might be a good example if you've got a supervisor or a town board member who has a CDL, and it's really hard to get highway department employees with CDLs right now. And you know, the Farmer's Almanac is predicting a snowy winter. So they may volunteer and say, I've got a CDL, I'm happy to help out where I can, but because they can't also be an employee of the highway department, you'd need a local law to supersede that. Anybody have any questions on compatibility of office? Yes?
Yes, just in the case where a clerk serves as a secretary for a planning board, and that person is voted onto the planning board, what would happen in that kind of situation?
So the question is, can you essentially be both the planning board secretary and a member of the planning board?
That's correct.
That's the question, and then the added wrinkle is you're also the town clerk. The town clerk, I think, is, you can put that one aside because it's compatible with both the planning board secretary and the planning board. So you don't have to worry about the town clerk piece of it. In terms of the planning board and the planning board secretary, under the town law, the planning board, subject to board appropriation, has appointment authority over their own staff, including the secretary. So you'd be looking then at the capacity of supervising yourself. You can't be chief cook and bottle washer. So you would need a local law in order to cure that conflict. Because recusal wouldn't work because you're showing up and taking the minutes, you're processing applications. You can't really recuse yourself.
Right, so the follow-up question would be, would that clerk then, who's taking the notes and posting those, if they vote, then they're actually reporting their own votes. Is that, you see what I'm saying? They're documenting that.
Well, if you've got the local law, I don't think that would be an issue. Or if it's a situation, some towns have consolidated the appointment authority over the planning staff with the town board. So if the planning board is not making that appointment, it wouldn't be an issue. It's really only a subordination issue if they're making the appointment and supervising that person. If they're being supervised by someone else, it's not an issue. But you can cure that with the local law. You know,
they would be voting to approve those minutes, and they're voting on their own minutes.
Well, the minutes are just an accurate reflection of what occurred. You can't rewrite history
Right. But
by
you
changing
vote
the
on
minutes.
it.
The vote,
If
you voted how you voted. Is it the best situation? You'd have to evaluate that on a case-by-case basis. If it's a situation where nobody else is able or willing to serve as the planning board secretary, and I know a lot of rural communities are having a lot of trouble finding people to volunteer for their planning and their zoning boards. So that might be a situation where using your local law exception authority works out. Yes?
Would the local law be subject to permissive referendum?
I'm sorry?
Would
Say
the
again?
local law be subject to permissive referendum?
I don't believe it would be subject to permissive referendum. And Sarah is adamantly shaking her head no. So I'm gonna go with a hard no. We don't believe it's subject to permissive referendum. We have a consensus. What?
No public opinion referendum. That's the situation.
Oh, okay. Katie is reminding me that we can't do public opinion referendums. So on a tangent here, the town can only put before the voters a proposition if there is express statutory authority for it, or authorization in a statute for it, or a court directive for it. Otherwise, it's considered a straw poll or a public opinion poll, and we don't have the authority to use the referendum process for that purpose. Yes?
You said you can't have two elected positions.
Correct, that's a prohibition in the town law.
Okay, does that?
Two elected town offices.
Okay, so last week at conference, or 2 weeks ago, I was shocked to see how many town clerks are also on elected school boards.
Well, that's a separate governmental entity. It's two elected town positions. There's also a provision in the county law that says you can't hold certain elected county offices and certain elected town offices. And a quirk in the town law and the education law, you can't be both a town supervisor and a member of a school board. I'm not sure why.
You can be a town clerk and.
But you can be a town clerk.
Okay.
I'm not aware of a statutory prohibition. There, I would suggest if you're a town clerk serving on your school board, you also need to vet the school's code of ethics to see if there's any prohibition there.
There was a lot of the conference, and it was like, can that be if you can't hold two elected positions?
Because they're separate entities. They're not the same municipality. Yes.
Okay, I need clarification when you said an employee of the IDA.
Oh, I knew that was going to come back to haunt me.
Well, Carthage Industrial Development Corp. I'm the administrative assistant. I'm not on the board itself, so I don't vote. I'm not an employee on the payroll. I'm an independent contractor.
Is that a local development corporation?
Yeah.
Or no, the statute applies to IDAs.
ID, okay.
And it
So I'm
has to be
okay
the
with it.
sponsoring municipalities and officers.
Okay.
So it's a county IDA. There might be a smattering of city, town, or village
So
IDAs,
local.
but mostly they're counties.
Okay, so I'm okay on that.
Well, I didn't research LDCs, so I can only tell you the statute that I referenced was for county IDAs. I don't know if there's a provision for LDCs, but you'd have to go through your
You mentioned an
analysis.
employee, but I'm an independent contractor. I don't have wages taken out of me or you know.
Again, you'd have to go through the steps to see.
Okay.
If there are no other questions, oh, yes, just one more, and then we'll move on. Sorry.
You mentioned earlier about elected official holding a position, a political party position that also is elected. Can you explain that?
That would be a choice that a municipality exercises in its code of ethics. The Attorney General's office has said that, in their opinion, a municipality can prohibit its elected officials, as an example, or its employees, as an example, from also holding political party positions. It's not a state statute that I'm aware of.
So they would prohibit that through a local law?
A local law or in their code of ethics. And if you need the citations, see me afterwards. I can get them for you. And Katie's going to talk to us about credit cards.
And there have been court cases that have also said there is one that comes up in the context of a planning board member that was also serving on a political party, and they were removed from office because the code of ethics prohibited that. I would so even though that's occurred, I would urge caution in just because, as Sarah has said, just because you're a public official, you still have the ability to be a person and to have views. So I would tread carefully if you're going to limit local political activity in your ethics code. Just be aware of that. And did the Farmer's Almanac actually say it's going to be a snowy winter, or was that just an example?
Just an example.
Oh, okay. All right.
I don't know what's happening in 2025.
All right. You know. It's already May. So a couple of things about credit cards. So how many of you received an email from the Department of State in January about the new credit card surcharge law that caused a lot of panic amongst local officials because why do we have to comply with this? So a couple of you, right? So the Department of State sent out this mailer saying that there's a new surcharge law, credit card surcharge law going into effect in February, and essentially what it is trying to do is to cut down on shady practices by businesses where they're overcharging or hiding their credit card fees. So that's who this law is targeting. But it was sent to local governments, making those that take credit cards think that there's an issue with the way they accept credit cards, and if they accept a credit card that we have to now use a special language that's in the general business law, specifically in section 518. Specifically that any credit card charge imposed by a seller, it says seller or businesses, has to be reflected in a certain way. So how does this apply to local governments? It's a great question. It really doesn't, in the sense that the general business law, section 511, defines a seller very specifically. Any person that honors credit or debit cards which may be used to purchase or lease property or services. So essentially, when you're acting in a governmental capacity, you do not meet the definition of a seller under the general business law. So this credit card surcharge law does not apply to your town and village charges when you're acting in that capacity. So this came up in the context of a lot of tax collection. You have a lot of individuals paying their taxes via credit card. Now do we have to have this reflecting a certain way? The answer is no. You're acting in a governmental capacity when you're accepting payments for taxes, for permits. So it's very clear there. If you want to have the new language sign up on your window, you can certainly do that, but you are not required to. So utilities, that's a great question that's come up. I still think that you're acting in a governmental capacity in that sense because you're although there are private entities that do provide utilities, your water, your sewer charges, that's generally a governmental function. So electric, I still think you're acting in a governmental capacity, even though that is an example of non-governmental entities providing a service. So if there's any sort of question about it, then I would urge caution in your credit card surcharge language. You might want to include a notice about that, but even still, you're generally acting in a governmental capacity. This comes up when, let's say you have a municipal golf course. So the way to think about it is if a private entity could offer this service, you are most likely not acting in a governmental capacity. You're acting in a non-governmental capacity, and this credit card surcharge law may apply to you. So if there's any question, golf course, just include the language. I still don't think you're considered a seller under the law, but just to cover all of your bases, you're going to include that difference. Yes?
We have a terminal for tax collection.
Mm-hmm.
We have a terminal for like dog licenses and stuff like that. The vendor that we use for those terminals does not charge the town.
Okay.
But we pass on that to the customer. It's $1.75 up to a certain amount, and then it goes up from there depending on the amount. But I always tell people there's a $1.75 surcharge. Is that okay?
The vendor does not charge the town a fee to use it?
Right.
No.
But that $1.75 goes to the vendor.
Oh, it goes to the vendor.
Goes to the vendor.
Okay, so you can, turning to the next slide, hey, all right, so you can accept credit card charges as a local government. It's via General Municipal Law, Section 5, and the law provides that you can charge back any costs associated with using credit cards. And a lot of local governments do, in fact, charge the cost back because you don't want to supplement someone getting all their points by paying their taxes via credit card and then the 2% fee or whatever it is. You can absorb that as a local government, but you're not required to. So it sounds like in this instance, you have the vendor that charges a fee for using the credit card. You can charge that back, so long as you're not making money off of accepting the credit cards.
Right. We get the basic amount, and then the vendor gets that $1.75
yes.
or whatever.
So yeah, then that's definitely appropriate. And in that context, we were talking about dog licenses, so that's a governmental function. So
okay.
Yeah, so you are all set with that.
Okay.
So any questions on credit cards? I think I said everything I wanted to say about it. I had thought that I just lost. Okay, so now another topic that's come up very frequently in the last year or so is the ability to waive penalties. The slides are a little out of order, don't mind that. So where does it say, oh shoot, they're still out of order, it's all right. So where does it say that I can't waive penalties for real property tax payments, and what if the taxpayer's check was washed? And there's a police report, can we waive it in that instance? So
What is washed?
so that's where the you put your check in the mail, and then someone comes, steals the envelope, erases or writes over the check, and then deposits. You know, it was written to the town of Clifton Park for $4,000. They steal the check, write to their own name. $4,500, $14,000 deposited. So the taxpayer, or maybe they just did $4,000, the same amount. The taxpayer thought it was paid, turns out it was stolen. And that's happening more and more frequently. They're recommending to not pay your taxes via checks because they're being stolen from mailboxes. You have people taking these little magnet things or sticky things, putting them in the mailboxes, pulling out the envelopes to steal
I had an
checks.
instance like that
Yes.
this year.
Yes, right, so it's these stories are crazy, but they are happening. So just getting to, in general, once the penalty-free period expires, there's no authority to waive any penalties for late tax payments. So I'm saying late, not delinquent. And it's right there in the law. So I have shall equals must bolded. That's the strongest statement you can get in the law. If you shall impose the penalty, that's a directive, you have to do it. It's difficult when you have a taxpayer that comes in the day after the penalty-free period, they had car trouble, they had something happen, please waive it. There's a lot of stories. I had one collecting officer where the person waited until 11:59 the night before the penalty period was triggered, 11:59 online, submitted it. It went through at 12:00:01, and they wanted the penalty waived. You were 0.01 seconds too late. You had to impose the penalty in that instance. So, yes. Well, you know, they're taking a stand. We're gonna wait until the last second to pay our taxes because, you know, but then they end up with problems and it's not your fault. So, I'm saying you can't waive penalties, but some of you may have heard of, there's the city of Albany and then some other localities waived penalties for those taxpayers that had their checks washed and stolen. So that happened in the city of Albany, the city waived it, and then a town nearby had a taxpayer come in and say, how come you waived the penalty for this person? I had this happen to me, and why aren't you waiving it for me? So delinquent taxes. So delinquent taxes are those taxes that you've already finished collecting your taxes, you've made your return of unpaid taxes to the county. So it's not taxes that are just late, you're in the penalty period now. It's you have closed out your collection cycle, you've made your return back to the county. Those taxes are now delinquent. So in Article 11 governs the in rem process, the foreclosure process in New York State, and it defines it allows taxing districts. So those are counties and everywhere outside of Westchester County, and then towns in Westchester counties are considered taxing districts, and cities in some instances. So the city of Albany can waive a penalty on delinquent taxes, so not while you're collecting, when they're in the delinquent phase, if it's in the best interest of the taxing district. So in this instance, it was the city of Albany, even though the taxes were not yet in that delinquent cycle, they were still a taxing jurisdiction that would eventually have the authority to waive that penalty. As a town, you're never going to have that authority unless you're in Westchester County, so that's why there's the difference there. To the taxpayer, that's not really fair, but Tax and Finance, the state said that even though Albany did it a little too early, they're still not going to go after that, or, they're not going to do anything about it because they had the ultimate authority to waive it since they are the taxing jurisdiction. So any questions on that before I turn it over to Sarah and civil service? Just one, okay.
I have a $2 late fee notice.
Yes, so
Some people don't pay that.
So if the town, you can impose up to $2. You're setting the second notice of unpaid taxes before you close out your warrant. So you used to have to impose that tax or that fee of $2 up to $2. Now it's an option, but if you have that policy, you do have to impose it. So then that would just be included in your return of unpaid taxes if they don't pay that $2. But you're not required to do it anymore. So if you're having trouble with it and the board wants to adopt a resolution removing that, for future reference, they can do that. There's no requirement. Okay, Sarah.
Okay, I'm gonna blow through civil service and deputy town clerk. So, if anybody's ever had county civil service say that they have to hire off of a list for their second or third deputies, has that happened to anybody? Or are you like, I don't even know how county civil service acts, right? This is gonna be a super quick primer on that. So every single position in the town is going to be classified in some way or going to be categorized in some way under civil service. So it's going to fall under initially a classified position or an unclassified position, and then among the classified position, everything is going to be, every position in the town is either going to be a labor, non-competitive, competitive, or exempt position. Town law, section 30, subdivision 10 says that basically a first deputy town clerk has the authority to act in the place of the town clerk when he or she is not available. It says that the second and third deputies are appointed by the town clerk. However, the town board has the option of setting forth those responsibilities, or the town board shall establish those responsibilities, right? They don't have to, they might not, but statutorily, the difference in the language here is really important because the first deputy under town law has the authority to act in place of the town clerk. Second and third deputy, we'll see what you guys are going to do. The town board is going to establish it. Why does that matter for the purposes of civil service? Because under civil service law section 41, it says that deputies of principal executive officers authorized by law to act generally for and in place of their principals will be classified under the exempt class. So that means, take it all together, the first deputy town clerk, statutorily, they have the authority to act in place of the principal. They should be in the exempt class. The second and third deputies, because statutorily the town board establishes their responsibilities, they don't automatically have the authority to act in place of the deputy. So sometimes county civil service will be like, hey, you need to hire off of a list. If they decided to make it a competitive position or a non-competitive position, you have to hire among a certain pool of people. And this makes, I can understand why this would rankle town clerks, right? Because you're like, hey, these are my deputies, I should be able to appoint who I want. But that is where that comes from, if anybody ever has an issue with that. There is a case from the second department. It's kind of old, but I haven't found anything more recent on it. And I think it's a good thing to hang your hat on, that says the town board can say for the second and third deputies that they can act in place of the town clerk and the deputy. And if they do that, then they should also be in the exempt class. So basically, the town board has the authority to say, hey, you can act in place of the principal, and this court case says if the town board does that, then the second and third deputy should also be in the exempt position. Why do we even care about this? Because as I said, competitive positions have to be hired off of a list of candidates, and also people in a competitive or non-competitive position in civil service are entitled to what's referred to as a Section 75 hearing if they have been in office or been in their position for 5 or more consecutive years, or if they're a veteran or volunteer firefighter. A Section 75 hearing, it's not that you can't discipline or fire somebody, it's just that it's a hurdle to overcome. It's a kind of a substantial hurdle to overcome. So if you're in the exempt class, you're not entitled to a Section 75 hearing. You can be disciplined in accordance with the town's employment policy. If you are competitive or non-competitive, and again, held a position for 5 years, or are a volunteer firefighter or a veteran, then you're entitled to the Section 75 hearing. And I'm not even going to take questions because I don't want to shortchange Lori and her early mail ballots in special town elections.
Thank you, Sarah.
9 minutes. Oh boy.
Okay, now you know all about civil service.
Okay, so, okay. So this is really just a public service announcement. This statute is brand new, came on the books January 1st, 2024, and I just really wanted to alert town clerks to this in the event you are having a special town election. Okay, so as I had said, came on the books January 1st, 2024. The parameters of early ballot voting by mail are outlined in Article 6 of the Town Law, which is your special town election provisions. Specifically, you're going to look at section 84-B. It sets forth the rules for town special elections and the ability to vote by early ballot by mail. It is required if your town offers personal registration for the special town election, and that is optional. Your town does not have to offer personal registration for your special town elections. If your town board chooses to do that, then your voters have the ability to request an early ballot to vote by mail. And section 84-B gives us the parameters. Just some questions have come up in my own mind particularly, but also in the public sphere. Is there a difference between absentee voting and early ballot voting by mail? Yes, there is. For absentee balloting, to get an absentee ballot, also the town has to have authorized personal registration for that special town election. But the voter has to have a reason why they are requesting an absentee ballot, such as they will not be in town on the date of the special town election. You do not have to have a reason to request an early ballot voting by mail. The statute has been challenged in court, and thus far, I think it went to the appellate division. Thus far, the courts have said that they believe that this construct is compatible with the state constitution, which generally had provided a voter has to either appear on election day to vote in person, or they have to have a reason to request an absentee ballot. However, the legislature has expanded one election day to allow for early voting, and this legislation is compatible with early voting. I can't tell sometimes if it advances. Okay, so again, the statute's going to tell you exactly what you need to do. I would recommend working with your county boards of elections, but essentially a voter who wants to be able to vote by mail through the early ballot system has to apply to the town clerk's office. And the statute gives us some basic requirements for what's included in the application. I think the State Board of Elections has an early ballot application on their website. I'm sure your county board of elections do as well. Probably a good idea to get one of those, and then you'll have a template that you can modify for your own elections. Cautionary tale, don't use your absentee ballot application because the voter will have to check why they're asking for it. For example, I'm going to be out of town on the day of the special election. You don't want to inadvertently include that in your early vote by mail ballot application. So the voter has to include their name and their address where they live, their residential address, and it has to have some particulars about that address, their street, their number, etc. And then they have to assert, they have to declare and sign a statement on the application that they are a qualified voter who is registered to vote in the town, that the information that they are providing in the application to the best of their knowledge is true, and that they understand if they're providing false information that they could be found to be guilty of a misdemeanor. Well, how are we doing it? Oh, I have 5. Oh, that's a nice sign. Thank you. Usually at our meetings we just flash our fingers. That's a nice sign. Okay, so the application has to be delivered to the town clerk. If the individual would like their early vote by mail ballot mailed to them, then they have to apply at least 7 days before the date of the special town election. If that ballot they want to have delivered to them personally or to the voter's representative, or what the statute calls the voter's agent, they have to apply and have that delivered to the town clerk at least the day before. Excuse me, I'm sorry. So who determines whether or not these applications meet the qualifications of the statute? That's going to be the special board, the Board of Inspectors that has been convened by the town board for purposes of that special town election. They will take the applications and they have the authority to review them to make sure that all of the information is present, that the individuals are actually qualified voters who are applying for these ballots. And they have the authority to actually ask questions, administer oaths if they want to dive in deeper if there's a question about somebody's status. They're going to, after they go through that process, they're going to give a list of the individuals that they believe are qualified who have requested an early mail ballot. It's a very weird way to say that. It's an early vote by mail ballot. And they're going to give that list to the town clerk. The town clerk's then going to mark who on that list has received a ballot. Okay. The town clerks, as I had said, the town clerk is going to make a list of the voters that were issued an early mail ballot. That list has to be available in the town clerk's office up until the day of the special election for public inspection, and it has to be posted in conspicuous places during the special election. Individuals can challenge or object to an individual who has requested an early mail ballot if you are a qualified voter yourself. And essentially the statute says you're a qualified voter if you are eligible to vote in that election. I think that's outlined in Article 6 as well, who constitutes a qualified voter. They can challenge it for any reason other than they should have applied for an absentee ballot. That is statutorily prohibited reason for objecting to it. And then those are set aside and given to the Board of Election Inspectors who review the objections. They have to state on the ballot, let's take a look at the early mail ballot itself. It has to be in the same form, essentially, and with the same content that if they would get by ballot if they were showing up in person, or an absentee ballot. It's got to include the same basic information. The statute goes into a little bit more detail about what has to be included on the envelope. I'm not going to go through all of the parameters of that right now, but it's all laid out for you in Town Law Section 84-B. And they have to be received by the town clerk no later than 5 p.m. on the date of the special election. So here we're talking about, again, some of the things that have to be on the envelope. And then you have to include instructions for the voter, how to fill out the mail ballot. And then these are collected, those that are given to the town clerk by 5 p.m. on the day of the special election. The town clerk gives those to the Board of Inspectors, who then canvasses them like they would any other vote. They have to go through the objections, and they have to make a decision on whether they agree or disagree. Here's some what they have to do. Are they sustaining the objections? Are they not sustaining the objection? And do they know if the individual who requested one of these ballots happens to be deceased as of the day of the election? And then if the envelope comes in and it's empty, they have to make a note of that. And then they're going to take those ballots that they've sustained the objections, the person is not dead, the envelope wasn't empty, and they're going to count all of those ballots and add that amount to the total. That's it, in a nutshell. Work with your county board of elections.